well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards, but I'm pretty sure you know that by now. I would hope so anyway. I do appreciate you being a part of today's program. We're going to be talking with Adam Kraut from the Second Amendment Foundation here in just a moment or two. The question of the week, what is up with Snope? We're going to pose that question to Adam, but we're also going to be talking about an issue that is percolating in multiple courts around the country in various guises. But the issue, I think, basically be boiled down to this. When do our Second Amendment rights kick in? Is it 18? Is it 21? Is it younger than 18? Maybe. This is very much a topic of discussion in multiple jurisdictions around the country. And these cases are getting to the point, at least a couple of them anyway, getting to the point where the Supreme Court could soon be asked to weigh in. Now, again, we don't know what the court's going to do since it seems to be playing its Second Amendment cards close to its collective vest these days, which actually is where we kick off our conversation with SAF's Adam Kraut. Take a look and a listen. Adam, thanks so much for coming on the program. It's good to see you, sir.
Yeah, thanks for having me.
Yeah, I got to tell you, when first started talking about doing this, I wasn't just hoping. I was kind of expecting that we would have some news from the Supreme Court to talk about regarding Snope. And the news is it's relisted once again. The orders list came out on Monday. No Snope, no Ocean State Tactical. So now I guess this is the seventh list, right? The sixth relist.
I think it's the sixth, yeah.
For Snope. I think Ocean State Tactical was around for like one more conference. So this is the seventh relist. Now I know that you don't have any hidden microphones in the Supreme Court chambers. So I know that you don't have any ins with what's going on here. But do you have any semi-informed speculation as to what might be happening here with these cases?
I'll give it my best guess with
the
caveat that I don't know. But what we can do, and I think what everybody who has an informed opinion on it does, is you look at, historically, how has the Supreme Court done things? And you look at data as far as petitions being relisted. One relist, the odds of a cert grant are still pretty good. And then as those relists continue, those odds start to drop dramatically. SCOTUS blog had an article that they looked at cert grants from like 2015 to 2020, and you looked in 2020 and the percentage hovered around like 40% for petitions that had been relisted one time of being granted, and then out of petitions that were relisted that ultimately were granted, it was in the 30 percentile. So judging from that, obviously the more number of relists, the less likely of a cert grant. The speculation that currently was going around was that the Supreme Court was trying to just push it to next term, not this current term. Mm-hmm. That still, in theory, could happen. There's realistically, there's a couple things that could happen. They could grant it outright. They could issue a per curiam opinion at some point. They could deny it, or more than likely, if it gets denied, there's going to be a rather fiery dissent, I would imagine. And the other odd thing is that it was paired with Ocean State, and Ocean State procedurally is in a very different position. So Snope is up on a Fourth Circuit en banc opinion. That case was originally, there was a cert petition while Bruin was pending. It was held pending Bruin, ultimately granted, vacated, and remanded, which means the Supreme Court granted the petition, threw out the Fourth Circuit's opinion, and sent it back down to the Fourth Circuit. So now there's an en banc opinion behind that. And Ocean State is up from the denial of a preliminary injunction, which the Supreme Court, if you look at statistically, hates those cases. Right. They just don't grant them because they want a case that's up there on the merits. So it's an odd kind of positioning that Ocean State wasn't just outright denied, regardless of whether there was a dissent saying like, we think X, but procedurally it's not where we want it to be. So that kind of hints towards maybe the Supreme Court is interested in tackling this issue. But, ultimately we don't know. And we're getting kind of tired of holding our breaths, honestly, every time there's a relist and then order lists coming out. We're waiting, and as soon as it's posted, we're searching to see if Snope's listed, and nothing. It's, come on.
Yes, that has been my Monday morning for the past couple of months now, is just, hitting refresh, starting about 9:29, just and then waiting and then scanning and make sure. And then I do a rescan. Did I miss it? Maybe I missed it. And then I'll go back through and I'm you are not alone in your frustration. And I'm an eternal optimist, so I'm thinking positively. I'm thinking, all right, well, listen. I mean, if they were going to deny it, there's plenty of time to write a dissent at this point. I don't think a pure curiam opinion seems really unlikely to me because I just don't see a 9-0 decision from the Supreme Court coming out either side, right? That
Sure.
either AR-15s are not protected or they are protected by the Second Amendment. I think we're going to see a split of some sort. And yeah, I'm keeping my fingers crossed that maybe they do just want to, punt this to the next term and we'll get a good announcement here, I guess, next Monday.
Yeah.
We'll be waiting. We'll all be waiting with bated breath, right? So in the meantime, it's not like Second Amendment litigation's on hold. When we're waiting to see what the Supreme Court does with Snow, but there are so many other issues out there, right? And one of the issues that is really coming up in different forms is, when do our Second Amendment rights kick in, right? Is it 18 or is it 21? And you've got multiple court cases that are taking on this issue, both in terms of buying a firearm, in terms of carrying a firearm. Then you've got legislation where, even now, particularly in blue states, you're seeing a push to raise the age to purchase a firearm. Colorado's got a bill that would raise the age to purchase ammunition from 18 to 21. And this is something that I know that the Second Amendment Foundation you guys have been very involved in, right? How many, multiple cases involving under 21s at this point?
Yeah, we have, off the top of my head, there's probably 5 to 7. 5 would definitely be on the low end because there's at least 2 challenges that deal with just the 18 to 20 handgun purchase issue. That issue in particular, the Fifth Circuit back in the end of January released its opinion in Reese, which reversed the district court in Louisiana's opinion that upheld the federal law. So the Fifth Circuit reversed and remanded that, and the timing on it was kind of funny because that day it was released, I was down at the Fourth Circuit for oral argument in our other case on this issue, which came out of West Virginia, where when I had left my prior employer, I started to litigate that issue for SAF in the time between when I left and when I started at SAF, which was only like a 2-month window. But that case we did win at the district court. And so that's up at the Fourth Circuit. And, odds are, based on how oral argument went, I suspect we'll get a 2-1 opinion now, the Fourth Circuit saying that, no, the law is constitutional. But I can't help but think that the Fifth Circuit was kind of trolling the Fourth Circuit as far as waiting to release that opinion until the argument day. So I expect that'll give us a circuit split. We also have dealt with the issue as far as 18 to 20-year-olds being able to carry. That coming in, Minnesota and Pennsylvania, and I believe one other state that's escaping me, but you get the Lara decision that came out of the Third Circuit that said that 18 to 20-year-olds are part of the people and they do have the right to bear arms in public. You have Worth out of Minnesota that said 18 to 20-year-olds are part of the people. We won that at the district court and the circuit court. They denied rehearing en banc from the request of Minnesota's government. That case is now up on a cert petition to the Supreme Court, where our reply to the Supreme Court is like, yeah, take this case. Like, let's settle this because 18 to 20-year-olds are part of the people. We've done other purchase challenges. We have one in Hawaii, Pinellas. We have another one that's in California dealing with, bans on long guns for 18 to 20-year-olds. So it's an issue that we're very involved in. And you look at the history of the country, which is what Bruin says and what Heller said. I mean, to be very clear, all Bruin did was clarify Heller and then also go further on the carry issue than Heller did. But, you look at the history, and historically 18 to 20-year-olds were not barred from possessing arms, purchasing arms, acquiring arms, any of that stuff, or the necessary ammunition. And that's part and parcel of being able to exercise the right. So we think we're in really good footing from a historical perspective. These new laws that are coming out, there's one of two things that will happen. Either we're going to challenge all of them as well, or the Supreme Court, will take the issue and settle it and say that, no, 18 to 20-year-olds are part of the people. And when we look at other constitutional rights like the First Amendment or the Fourth Amendment, not only do they apply to that age bracket, but they apply to people who are not adults. And, being in elementary school, you look at Tinker versus Des Moines,
Right.
an old Supreme Court case. You look at any number of these Fourth Amendment cases that deal with the searches of school lockers and other things and students personally. And while it does raise a very interesting question, and that question is, okay, well, if we settle that 18 to 20-year-olds do, in fact, have Second Amendment rights, which I believe is very clear based on our nation's history and tradition, the next question is, well, what about those who are younger? Can states effectively ban their possession or use of firearms? And I think ultimately you'll find that some of those restrictions, I suspect, would be held as constitutional, that age bracket below 18 may not have full Second Amendment rights, but I don't think that they can be stripped entirely of their Second Amendment rights. But that poses a question downstream of this one.
Yeah. Yeah, absolutely. And in the immediate, term, I obviously I've got my own bias here. But I got to say, the argument that we've heard from, for instance, the argument I suspect we're going to hear from the Fourth Circuit, the argument that we heard in the NRA challenge down in Florida, which is now pending before the 11th Circuit. And boy, they've been holding on to that opinion for a while now. What you just talked about, to me, it's so clear, right? The Second Amendment, the Supreme Court has said the Second Amendment, again, applies to, at the very least, members of the political community. Right. That we, the people. So who are the people? And they've said, again, at the very least, it's members of the political community. Well, it doesn't matter if 18-year-olds couldn't vote in 1791 or in 1866. They can vote now. Right. You are a legal adult at the age of 18. You are considered a part of the political community at the age of 18. And so to me, at the very least, that's when our Second Amendment rights should be fully vested, when you are a legal adult. What is the argument that what are these judges saying? And what is the rationale that they're using when they say, no, actually 21, that's when your Second Amendment rights kick in? Because they say the history really isn't there. At least no fine, bright line showing that, you had to be 21 to exercise your Second Amendment rights in 1791. So what are they pointing to in trying to uphold these age-based restrictions?
Yeah, so the government and some of these judges are pointing at that back in 1791, 18-year-olds were not legal adults. The age was, in fact, 21. Now, part of the argument that came up during the Fourth Circuit's oral argument was that, 18-year-olds at that time couldn't contract. And so it went into purchasing and is that a contract? And all these, legal theories that if you went to law school, you'll kind of smile and chuckle about how kind of clever that is. But if you didn't go to law school, you're just wondering what that has to do with anything. And so they're kind of hanging their hat on at the time that 18-year-olds were technically minors in that point in time. Now, the problem with that becomes, how do you square a couple of things, right? Because at that point in time, only white landowning males could vote.
Right.
Minorities, Indians, and others were said to not have any kind of rights, which today would be blatantly unconstitutional. So just because at that point in time they were minors, well, okay, fine, but they're not minors anymore. And also at that point in time, those individuals also were expected to show up for militia service with firearms, their own firearms and things like that. So again, I think when you look at the historical nature of it, yes, maybe they were technically minors, but today they're not. So trying to square that is kind of rough. And on top of that, those individuals were expected to muster for militia service with their own firearms. And there was nothing at that point in time that either prohibited them from acquiring them or otherwise. You could get into the contract theory, but I guess if you showed up with a boatload of cash to your local firearms manufacturer, I'd be hard pressed to believe that they would not sell it to you based on your age. And there's nothing that anybody's uncovered to my knowledge that shows yes, this actually happened. Somebody showed up with cash and they said, no, you're 18. Sorry, too bad. So sad.
Right. Yeah. The first argument to me seems to be the more important one, right? The Supreme Court has said that the Second Amendment exists unconnected to service in a militia. So, we can point to militia laws. I don't think that's necessarily all that relevant, right? But if you are a judge and you're saying, well, 18-year-olds weren't considered adults back then. They weren't considered part of the political community, so it's fine to deprive an 18-year-old today of their Second Amendment right. I mean, does that mean that some misanthropic legislature somewhere could pass a law saying women can't own guns and the court would be obliged to uphold that too? I mean, that's taking that argument, right, to its logical,
and turning it on its head.
quote unquote conclusion. So that's why I feel like we're actually on pretty firm footing here when it comes to the argument that yes, 18, 19, and 20-year-olds do possess the Second Amendment rights. But I'm glad that we've got groups like the Second Amendment Foundation fighting this good fight, as you say, in courts across the country with a half dozen or so lawsuits. And Adam, listen, I obviously, with more than 50 active cases around the country, we could have you on every day for 2 months and probably not repeat ourselves. But I don't want to wait. I don't want to have you on every day because I think our audience might get bored of you and I just talking. We'd have to start talking about music, other activities,
other things. Yeah.
But will you come back in like a week or two so we can touch base again?
Yeah, absolutely.
Okay, great. And if folks, obviously, if you want folks to learn more about the Second Amendment Foundation, become involved, how do they do that?
So there's a couple ways. The easiest is the website, saf.org. You can check out all of our stuff. Our cases are listed there. There's information as far as what's going on in them. You can find the dockets. There's different various news releases as well. And of course, if you want to join or donate, there's options to do so in the top right-hand corner. And the other best way to stay informed on what we're doing is our social media. So we're on Instagram, X, Facebook, YouTube, and LinkedIn as well. So all of those handles are Second Amendment Foundation, other than X, which is 2AFDN, because the other one was too long apparently for them to use. So,
all right. Well, that was the pre-Elon days of X, right? All right, Adam Kraut, thank you as always, man. This has been a great conversation, and look forward to the next one.
Yeah, thanks for having me.
And thanks to Adam for joining me on the program. Looking forward to doing this again here very soon with him. Coming up on Monday's program, we're going to be talking with Second Amendment advocate Kellen Lanier out in Colorado. I ran across a piece that Kellen wrote, I guess it was his late February or so, talking about the racist progressives there in Denver. A Colorado lawmaker reveals allegiance to the South's historically racist gun laws as a basis to deny rights. Fascinating column by Kellen, and it's going to be a great conversation as well. So I'd encourage you to check that out on Monday's Bearing Arms Cam and Company. Right now, let's turn our attention to today's armed citizen story, our good deed of the day, and our recidivist report. We will start there with a case out of Birmingham, Alabama. Birmingham had a record high number of homicides last year, and the mayor, Randall Woodfin, has been blaming Alabama's gun laws, has been blaming constitutional carry. Never mind that homicides went down in Montgomery, went down in Huntsville. Not sure about Mobile, but it was Birmingham that we really saw homicides explode. And in fact, most constitutional carry states saw their homicide rates decline last year. So to pin the blame on Alabama's gun laws, I think is short-sighted. I think it's also politically expedient for a mayor to say, forces beyond my control, right? And I'm not sure that this is actually under Mayor Woodfin's control either, but it is, I think, an example of maybe why violent crime is such a problem in Birmingham. This headline here: man gets out of jail, allegedly shoots and kills an expectant father in Birmingham 24 hours later. And the story really is as infuriating as the headline sounds. Malik Quinton Austin, now charged with capital murder in the February 15th killing of 21-year-old Trevon Naeem Douglas. Austin was arrested on Monday on an unrelated outstanding probation violation warrant, taken to police headquarters, interviewed by homicide detectives, and then booked into the city jail on a 48-hour hold, according to police, on Wednesday. It was, again, back on February 15th when neighbors reported hearing a loud bang. They found Douglas on the ground in the backyard of his home. They called 911, but he was pronounced dead on the scene. Apparently, he had left home that day with Austin and another man, according to Alabama.com or AL.com. His girlfriend became concerned when she couldn't reach Douglas, and then Douglas's mother and brother all began trying to reach him. Eventually, his girlfriend reached out to Austin, but he told her only that he had dropped Douglas off somewhere and was going back to pick him up. His mom, Douglas's mom, Sherry Hayes, said, he was out on his own. He was doing something for himself. He was my baby. He wasn't a troubled child. Didn't hang out in the streets. It's still unclear what he was doing with Austin that day. But the day before, so I guess it would have been Valentine's Day, February 14th, Austin had been released from the Jefferson County Jail after Judge Stephen Wallace continued his probation on a previous robbery conviction. So last September, 6 months ago, 5 months in February, right? Austin pleaded guilty to first-degree robbery and was sentenced to 20 years behind bars. But all of that was suspended except for 1 year. So 20 years with 1 year to serve. But even then, he was given credit for time served, and he was immediately freed. So a 20-year sentence turns into you're free to go. He was placed on supervised probation. But again, within less than 5 months, the judge had already modified the terms of his probation, and he had been on unsupervised probation. In November of last year, so this is, a month after he pleaded guilty to robbery, Austin was arrested for being a convicted felon in possession of a firearm. That could have resulted in his probation being revoked. It was not. January 29th, about 2 weeks before Douglas was murdered, Birmingham police arrested Austin again for being in possession of a stolen pistol. So you got a convicted felon, not allowed to possess a firearm, who's now been caught not just in possession of 2 guns, but now on a separate occasion caught with a stolen gun, which again could have resulted in the judge revoking Austin's probation, sending him to prison. Honestly, he could have been sent to prison for the entire 20 years, but he could at least have been sent to prison for that year to serve, right? Nope. Instead, February 13th, the judge issued an order continuing Austin's unsupervised probation, despite 2 arrests since that guilty plea, since he walked out with time served. And then again, that was February 13th. He was released from jail 11:37 a.m. February 14th, and Douglas killed just over 24 hours later. Now, you are innocent until proven guilty in a court of law. And Malik Austin has not been convicted of the murder of Trevon Douglas. So I won't say that he was responsible for Douglas's death. But I will ask, what the bleep was this judge thinking in continuing unsupervised probation for somebody who had racked up at least 2 additional felony charges since being placed on unsupervised probation? So, Mayor Randall Woodfin, if you want to try to figure out what's going on in Birmingham, why violent crime is out of control, I'd say start with the courtroom of Judge Stephen Wallace and see what else you find there before you start blaming constitutional carry and law-abiding gun owners. All right, on to today's armed citizen story. From Lake City, Florida, where police say an intruder was shot to death during a home invasion this week. It was just before 11 p.m. on Tuesday when officers arrived at the home in Lake City. They found a man shot and unresponsive. Police unsuccessfully tried to resuscitate the man. A news release from the Lake City Police Department says victims of the home invasion reported that the individual, who was known to the victims, attempted to break into the home and was successful. The residence contained multiple adults and children. One of the adults fired multiple shots at the intruder when he rushed towards them. At this point, again, this would appear to be a pretty clear-cut case of self-defense. Somebody's breaking into a home where they have no right to be. You can assume that they're not there to deliver Girl Scout cookies or drop off the, Tuesday paper. So we will keep our eyes open for any additional information about this, maybe the relationship between the intruder and the individuals inside, but no arrests of any of the homeowners or the armed citizen who acted again in defense of themselves and all of the other occupants of that home. Finally, today, our good deed of the day, in the right place at the right time, willing and able to do the right thing. A high schooler in Tennessee who saved a man's life at the local YMCA by performing CPR. This is not the same story we had last week of another teenager who learned CPR in school, who put that education to good use, and I think saved like 2 people in 2 weeks, right? This is a different story altogether. Sumner County, Tennessee, WSMV reporting on the quick thinking and fast actions of Caitlin Williams. She is a senior at Liberty Creek High School. Wasn't really sure what she wanted to do or what she wants to do after she gets out of school and what she wanted to major in college. She was thinking about healthcare, and she had been taking some nursing courses. 3 weeks ago, she's there at the Hendersonville the Sumner County YMCA in Hendersonville. There for workout. There's a guy there named Billy Austin who ended up collapsing in the men's locker room. He said, I sat down and that's the last thing I remember. So one of the other guys in the locker room comes, tearing out and yelling for help. Caitlin Williams runs into the locker room. She finds Austin. He's unresponsive on the floor. She said, knowing something was clearly wrong, she started performing CPR. She said, all I could think about is this is somebody's person. And so I just gave it my 100%. As she's performing chest compressions, there were 2 nurses who actually worked at the hospital there in Hendersonville. Paula Carney's one of them. She said, we were just taking care of someone who needed help. No talking, just working, communicating with each other. So all 3 of these individuals are now helping to keep Billy Austin alive. Williams, after Austin was taken to the local hospital, said she had a hard time falling asleep that night. She said, I just wanted to know if he was okay. She got her answer 3 days later when she was able to visit Austin at the hospital. He called her his angel. And he told the local TV station, I just thought, wow, this is unbelievable that we're having this moment right now. She immediately became a daughter. To me, it was just like an instant, I'm going to be here for her for anything she ever needs forever. And as long as I'm here, I'll be here to help her. That's a nice thing to say. But I think it is even more poignant given that Caitlin Williams' dad passed away when she was young. And she says that Billy Austin has become someone that she can turn to and lean on in the future. She said, we have this relationship. He wants to come to my prom. He wants to come to my graduation. He wants to see me succeed and do all of these things. She said, me going through this experience now, it's like Billy is that figure to me that I lost when I was young. So in the right place, at the right time, willing and able to do the right thing, to save the life of a stranger in need, and to gain an invaluable addition to her own life. Caitlin Williams, we thank you. Not just Billy Austin, but we thank you for your very good deed. All right, that is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you for being a part of the program as always. Looking forward to seeing you back here again on Monday. Be sure to check out bearingarms.com between now and then. However, we're keeping you up to date on all of the latest Second Amendment news and information from all across the nation. And if you like what you see, I would encourage you to become a VIP Gold, or VIP Platinum member. You'll get exclusive benefits at every tier of your membership. But no matter which level you sign up for, you'll be supporting the independent pro-Second Amendment journalism that we're doing at Bearing Arms, and I so greatly appreciate that. So thank you again. All right. Have a good weekend. We'll see you back here soon. Until then, be well. Be safe. And be free.